These are common doctrines in civil law with case examples, part 1. So, doctrine of stare decisis. It means courts should follow previous rulings or precedents to ensure consistency and predictability in the law. Example, in the case of Tan Chong versus Secretary of Labor 1947 case, the Supreme Court of the Philippines followed the precedent in interpreting labor laws. Doctrine of res judicata. It means a final judgment by a competent court is conclusive and prevents the same parties from relitigating the same issue. For example, in the case of Abuitis Shipping Corporation versus Court of Appeals 1996 case, the court upheld that a final judgment in a previous case between the same parties was conclusive. Doctrine of Laches. It means a legal claim may be barred if there is an unreasonable delay in pursuing it, causing disadvantage to the other party. Example, in the case of Republic versus Court of Appeals 1995, the court ruled that a party who delayed in asserting their right lost the ability to do so. Doctrine of Estoppel. It means a person cannot deny a fact that has already been established by their own previous actions or statements. Example, in the case of Heirs of Ramos versus Court of Appeals 1995 case, the party was prevented from denying the existence of a fact settled in a previous transaction. Doctrine of last clear chance. It means the party who had the last opportunity to avoid an accident but failed to do so is held liable. Example, in the case of Philippine Rabbit Bus Lines Incorporated versus Intermediate Appellate Court in 1986, the driver who had the last chance to prevent the accident was held liable. Doctrine of contributory negligence. It means that if the plaintiff's own negligence contributed to their harm, then their compensation may be reduced or denied. Example, in the case of Mercury Drug Corporation versus Wang 2006 case, the court apportioned liability due to the injured party's partial negligence. Doctrine of vicarious liability. It means an employer is liable for the actions of their employees if such actions occur within the scope of employment. Example, in the case of Castilex Industrial Corporation versus Vasquez 1994 case, the employer was held liable for the acts of its employee committed during employment. Doctrine of command responsibility. It means a superior is responsible for the actions of their subordinates if they knew or should have known about the misconduct and failed to prevent it. So for example, in the case of Yamashita versus Tire 1946 case, General Yamashita was held responsible for the atrocities committed by his troops. Doctrine of attractive nuisance. It means property owners may be liable for injuries to children who are attracted to and harmed by the hazardous objects or conditions on the property. Example, in the case of Victoria versus Court of Appeals 1998 case, a property owner was held liable for injuries to a child who was attracted by a dangerous condition on the property. Doctrine of res ipsa loquitur. It means the mere occurrence of an accident implies negligence when the instrumentality causing harm was under the control of the defendant. So, example, in the case of Picard versus Smith 1918 case, the court inferred negligence from the mere occurrence of the accident under the defendant's control. Doctrine of assumption of risk. It means a person who voluntarily exposes themselves to a known risk cannot claim damages for injuries resulting from that risk. Example, in the case of Air France versus Carrascoso, a 1966 case, a person who voluntarily participated in a risky activity could not claim damages for resulting injuries. Doctrine of parens patriae. It means the state has a duty to protect individuals who cannot protect themselves, such as minors or those who are mentally incapacitated. Example, in the case of People versus Vera, 1937 case, the state exercised its role as guardian of persons under disability, such as minors. Doctrine of forum non-convenience. It means a court may decline to exercise jurisdiction if there is a more appropriate forum available elsewhere. For example, in the case of Reyes versus Marine Transport Services Incorporated, 1998 case, the court declined jurisdiction because a more appropriate forum was available in another country. Doctrine of abuse of rights. It means a person exercising their rights in a manner that unjustly damages another may be held liable for abuse of those rights. Example, in the case of Solid Bank Corporation versus CA 2002 case, a party was held liable for exercising a legal right in a way that caused unjust harm to another. Doctrine of alter ego. It means if a corporation is merely an extension of an individual or another entity, the corporate veil may be pierced, holding the controlling party liable. Example, in the case of Pala Incorporated versus Clave, 1981 case, the corporate veil was pierced because the corporation was merely an alter ego of the individual controlling it. Doctrine of imputed knowledge. It means that knowledge acquired by an agent within the scope of their authority is legally attributed to the principal. Example, in the case of Panlilio versus Citibank, 2006 case, the knowledge of a fact by an agent was imputed to the principal, affecting the principal's legal standing. Doctrine of relative nullity. It means a contract that lacks essential elements or necessary consent is voidable and may be annulled by the injured party. Example, in the case of Nera versus Remando 1955 case, a contract was declared voidable due to the lack of necessary consent. Doctrine of proximate cause. It means the primary cause of an injury must be a natural and probable consequence of the defendant's action. For example, in the case of Philippine Airlines versus National Labor Relations Commission, 1993 case, the injury suffered was the direct and foreseeable result of the defendant's action. Doctrine of contributory negligence. It means a plaintiff's own negligence that contributes to their injury may reduce the damages they can recover. Example, in the case of Cebu Institute of Technology versus Ople, 2001 case, the injured party's own negligence was considered in determining the damages recoverable. Doctrine of Lex Loci Celebrationes. It means the validity of a marriage is determined by the law of the place where the marriage was celebrated. For example, in the case of Van Dorn versus Romilio, 1985 case, the validity of a marriage conducted abroad was determined based on the laws of the place where it was performed. That's it. I hope you learn a lot from that short video. If you want more videos like this, please like, share, and subscribe. And watch out for part 2 with more doctrines on civil law. Thank you very much.